Yeah, so we would like to continue with our discussion of company law. And tonight we would like to look at an aspect of corporate governance called directors. But as we have noted before, the concept of corporate governance actually refers to set of processes and arrangements for governance of the company, for giving direction or administering or managing the company. So that is the corporate governance. And one of the very important pillars in corporate governance discussion is officers we call the directors, and we would like to spend a bit of time discussing them. So what we are going to be discussing would include understanding who directors are conceptually. When we say directors within company law, within corporate law, what exactly do we mean? What are the various types or kinds of directors recognized by our company law? Who qualifies to be a director? And who is that disqualified from being a director? How are directors appointed? How are directors removed from office? And then we come to the very important issue of remuneration of directors. How are directors remunerated? How are they compensated for their services to the company? And what exactly do directors do for the company? What duties do they owe the company? Do directors owe the company duties, or apart from the company itself, they also owe duties to some other stakeholders, some other constituencies? And then finally, enforcement of duties or obligations of directors. Where directors default in carrying out their duties, in carrying out their obligations, what remedies are available to the company? What remedies are available to individual shareholders or members as it were? So these are the matters that we'll be discussing or we'll be exploring in this particular lecture. And as I said, if you have any question as we move along, you can raise up your hand and then we'll allow you to speak. Because you do not want interruption, some of you forget to put your mic up. That is why we have muted everyone. But if you want to speak anytime, please feel free and then raise up your hand and we will actually invite you to contribute. So as I tell you all the time, our primary material will be the law itself, which is Act 992, and we are particularly interested in discussing the whole of section 170 up to section 210, and then we will be done with directors. But again, I would also encourage you, in addition to these statutory provisions, which we are going to be analyzing and discussing, to also supplement your reading with my good friend's work, which I'll be referring to. That is a company law in Ghana by Ferdinand Adaje. I'm referring to Mr. Adaje's book, especially if you look at the chapter on directors, which is chapter 13. So from page 534 up to page 700, up to page 708. If you look at that, I think it will be a useful supplement to the discussion that we are going to do. Good. So first and foremost, who is a director? Who is a director? But before we look at who a director is, it is very important for us to remember that if we remember theory of incorporation of companies, we said that the company, upon being incorporated, that is, upon being registered, becomes an artificial person, right? Becomes an artificial person, which can sue and be sued, who can enter into transaction in its own right, and so on and so forth. But then, it is also true that being an artificial person, the company does not have hand. The company does not have leg. The company does not have mind. And for that matter, the company will have to function through the instrumentality of human beings. And these human beings, through whom the company will have to act, most of the times are what we call directors. Directors. And that is why in the case of Aberdeen Railway against Blackie Brothers, Lord Canwolf will make the point, which we have just paraphrased, that the company function, does not have a flesh and blood, isn't it? And for that matter, it functions through the directors. The directors are the mind and the leg of the company as it will. So if the company, the directors are the mind and leg and hand of the company, the question is, who is a director, or who are directors for purposes of our company law? To answer that, we don't have to go far. We have to look at section 170 of Act 992, and we will be told who directors are. And then let me say that because Company Act 2019 Act 992 is a legislation like any other legislation, it has its interpretation session. So the first schedule, which is at the tail end of the act, if you go to the tail end of the act, starting from page 301, we have like the first schedule there. And it is headed definitions, right? Definitions. That is to say that if you want to understand any concept, go to the first schedule first to find out if that concept or that word has been explained or defined there. If it has been defined there, it is a definition provided there, which will be the necessary definition for understanding that particular concept or word within the context of our Companies Act 2019 at 992. So therefore, if you go to the first schedule, right, the word director has been defined there. And this is what it says, and I quote, director in relation to a company has the meaning assigned to it by section 170, and relation to any other body corporate means a person whose position in relation to that body corporate is one that person will be a director of the body corporate if the body corporate were a company. Good. So if you look at the Schedule 1, you notice that in terms of the definition, it has referred us back to section 170. Can anybody use the chat to confirm if you are hearing me? Because I don't see my mic moving. Are you hearing me? Can anybody use the chat? Okay, let me see. Okay, all right, thank you. Good. So the first schedule in trying to define who a director is refers us back to section 170. So let's come to section 170 then. According to section 170, directors means those persons, by whatever name called, who are appointed to direct and administer the business of the company, unquote. Now, this definition in section 171, I call it a functional definition. Functional definition, or if you like, utilitarian definition, in the sense that the emphasis is not on the designation, is not on the nomenclature or the label or the taxonomy or the title which is given to a person, but the emphasis is on the substance of what the person has been appointed to do. And that is why 171 of Act 992 is reminding us that you are a director for purposes of company law if you are appointed to do two things: to direct and administer the business of the company. So if you are directing and administer the business of the company, then to all intent and purposes, you are a director. Of course, directing also include some administration, isn't it? Or administration also include direction. But I'm sure that these two words are there as an overkill provided by the lawmaker for the sake of emphasis that if you have been appointed to direct and administer the business of the company, then you are a director. And don't forget, according to Solomon and Solomon, we notice that the company is artificial legal person, separate from the incorporators. But the emphasis is artificial, being artificial or juristic person. The company does not have eye, it doesn't have leg, it doesn't have hands. So how can it do all those things which we learned from the incidents of incorporation? That can sue and be sued, it can enter the contract in its own right, and so on and so forth. It needs some people to do that, and those who do that are the directors, those appointed to direct and administer the business of what? Of the company. So let us keep that in mind. Very important. So as I said, the emphasis is on the function of what the person is appointed to do and not the label. And for that matter, in some companies, they may not even use the word director. They may use the word governors. They may use some other terminology or board of advisors or whatever. That is not important. What is important is that regardless of whatever those officers are called, are they appointed to direct and administer the business of the company? If the answer is yes, then the person is what? Is a director. So let us keep that in mind. Again, we should also remember that there are some persons who have not actually been appointed as directors, and yet either on their own they are behaving in relation to the company and towards third parties as directors, or the company itself or some other officers within the company are letting third parties, letting the outside world recognize or see these persons who have not actually been appointed as directors. And that is why section 170 subsection 2 is important. And let's quote that. A person not being a duly appointed director of a company, A, who holds out as a director or knowingly allows to be held out as a director of that company, or on whose instructions or direction, on whose directions or instructions the duly appointed directors are accustomed to act, is subject to the same duties and liabilities. I've seen that person where a duly appointed director of the company, unquote. Yeah, so section 170 subsection 2 is referring to what we call like the two category of persons who are not directors appointed as such. What we call, if you like, a de facto, right? A de facto director, and then what you call like a shadow director. If you look at the English company law literature or textbooks, you will come across those terminologies. So with respect to section 170, subsection 2A, someone is holding himself out as a director. He's not appointed a director. That is to say that despite the fact that he's not appointed a director, he's directing or administering the business of the company. Or the person is actually holding himself out as a director of that company. And he knows that he is holding himself out as a director when he has not been appointed as a director. And don't forget that when it comes to appointment of director, we will very soon be learning that when you are appointed a director, among other things, you are supposed to accept the appointment in what? In writing. So later on, when we are discussing the, if you look at the section 172, subsection 2B, that when you are appointed director, you must consent in writing to be a director. And that should be filed within 28 days of the appointment. So that is to say that being appointed a director or becoming a director is a conscious act. A conscious act in the sense that you've actually been elected or appointed and you have accepted to be so appointed. So there's no ambiguity about that. And that is why section 170 subsection 2 is saying that if you are not appointed the director, but you hold yourself out as a director, or you knowingly allows yourself to be held out as a director. And this knowingly allowing yourself to be held as a director is referable to section 172, the subsection 3, which we look at, that when you're appointed the director, you must consent in writing. So if you've not accepted in writing to be a director, you know that you've not been appointed a director. So if you are doing anything in the form of you directing and administering the business of the company, when, as a matter of fact, you've not been appointed, you've not accepted appointment in writing, that is what section 170, subsection 2A is referring to. So in that case, you are sort of, if you like, a de facto, right? A de facto director. That is a director, in fact. You are doing everything as a director. That's why the fact that legally speaking, strictly legally speaking, you've not really been appointed. Now, the second scenario is, if you look at the English criminal law literature, maybe they use the language called shadow director, okay? Shadow director. And of course, as I said, that language is not used in our 992, but the substance or the essence of section 172B, it actually speaks to that. That is a person on whose directions or instruction the duly appointed directors are accustomed to act. So somebody has properly been appointed a director, and he has consented in writing, as we have seen, to be appointed a director. And you have not been so appointed, and yet you are the one who calls the shots, who give directions, who give instruction for this duly appointed director to exercise his or her directorship. And that is why in English company law, they call shadow, right? Shadow in the sense that you are, if you like, behind the scenes. And the duly appointed director is actually directing and administering the company according to your instructions. Now, when you find yourself as falling within any of these two scenarios, either you're holding yourself out, don't allow yourself to be held out, or you are behaving as a shadow director, that is, as you directing and instructing the duly appointed director, the law will treat you in terms of duties and liabilities in the same way as it will treat appointed directors. In other words, when there's a problem and you are identified as someone who actually acted as a de facto director or a shadow director, I mean, in terms of section 172A or 172B, the law is going to hold you to the same standards of behavior and propriety expected of duly appointed directors, so that all the duties that will be learning as duties of the directors. That the directors are fiduciaries. They are supposed to act in good faith. They are supposed to be diligent and exercise ordinary care and skill, avoid secret profit, avoid conflict of interest, and all those things, which we'll be discussing. They are applicable to you, despite the fact that you have not actually been appointed what? A director. Similarly, where you commit malfeasance or you indulge in wrongdoing vis-a-vis or in relation to the company during the period that you held yourself out, or you allow yourself to be held out as a director, or you were instructing or directing the duly appointed directors, you'll be made to face the same liability as a duly appointed director. Now, the wisdom of the law in this regard is to discourage people who have not been appointed directors to actually behave as directors in relation to the company and also third parties. And that is why 172 will say that if you are behaving as a de facto or shadow director, they are going to hold you to the same duties and liabilities. But did not say that they are going to hold you to the same rights and privileges of a duly appointed director. Duly appointed directors are entitled to certain rights or privileges, including payment of remuneration and so on and so forth. But you, as a busybody in the sense that nobody has appointed you a director, you are holding yourself out as a director, or you allow yourself to be held as a director. You will not be actually be accorded the privileges or the benefits or rights which are enjoyed by those who are properly being appointed directors. Maybe on this point, there is an interesting Ghanaian case, which I would like you to look at. And I think that we came across it somehow when we were discussing some of the things in the last semester, the Commodore against the Food Supply Limited. Does anybody remember that case? Commodore against Food Supply Limited. Anybody? Let me put it in the chat for you to see. Commodore versus Fruit Supply Ghana Limited. 1977. JLR 241. So Commodore against Fruit Supply Ghana Limited, 1977, Ghana Law Report 241. In that case, the responder company was incorporated with two directors to engage in the business of trading in frozen fish, that is selling frozen fish. And the company required a license to be able to do this business. So one of the directors who had two roles, he was the board chairman and at the same time managing director of the company. So as a managing director, he engaged the assistance of one gentleman known as Atokwashi to assist with obtaining the license required for the importation of the frozen fish. Now, after obtaining the license, the managing director requested assistance of Atokwashi again to raise money required to start the business. And Mr. Atokwashi assisted in obtaining money from the appellant on terms that required the company to provide all the frozen fish to Atokwashi to sell. And after Atokwashi recovered the money given to the company to continue to take delivery of fish on credit that were sold and payment made to the company. So, in the light of the role played by Mr. Atokwashi, it was agreed to pay some of the profit of the company to Mr. Atokwashi, which was actually done by the appellant, paying money into Mr. Atokwashi's personal bank account. On various occasions, Mr. Atokwashi also acted on some transaction of the company as a director. He had not been appointed a director, but he acted as a director, and his name was printed on the letterheads of the company as the director of the company. And this is another dangerous thing. You know, if you look at the law, directors are supposed to have their names on the letterheads of the business and circulars of the company. But Mr. Atokwashi had not been appointed a director, and yet his name was put on the company as a director. So the company alleged that the appellant failed to pay for the fish, which have been supplied with by the company on credit basis. And for that matter, brought a suit to recover the money involved. The appellant alleged that he has paid the money into Mr. Atokwashi's personal account for the company, and for that matter, made a counterclaim that the money which he had paid into Mr. Atokwashi's personal account should be refunded or returned to the appellant. The company denied that it has authorized Mr. Atokwashi to engage in those transactions with the appellant. That is to say that the company said that, well, we had never asked Mr. Atokwashi to be collecting any money, so we don't really know what you are talking about. So when the matter was before the High Court, the High Court ruled in favor of the company and dismissed the counterclaim. In other words, the High Court said that yes, the company was entitled to recover the money from the appellant, and that the appellant was not really entitled to demand a refund of any money which had been paid into Mr. Atokwashi's personal account on behalf of this company. The matter was appealed. The High Court decision was appealed to the Court of Appeal, and the Court of Appeal came to the conclusion that Mr. Atokwashi was the director for the company, even though he was not duly appointed. And in the judgment of the Court of Appeal, one of the justices who wrote the opinion, Justice Lassie, made a statement in relation to Mr. Atokwashi holding himself out as a director. And I quote portions of the judgment, just a portion, I'll just leave it, and I go and read the judgment yourself. So somewhere, His Lordship said, and I quote, From the above conclusion, broadly, two questions seem to arise in my opinion. They are these. One, was Ato Kwashe a director of the company? The first question was factually answered by the learned judge in the negative, but it was submitted that he was wrong in his finding of fact. The judge decided as a fact that Ato Kwashe was never appointed a director in the company, and that there was no evidence that he had instruction to receive payment from defendant on behalf of the company. The question is, was the judge right in so holding? The contention on behalf of the company was that the judge rightly decided that Ato Kwashe was not a director because there was no evidence that he was ever appointed to such a position in the setup of the company. Then the judge continued, and I quote further, as the company is an artificial person, it can only act normally through human agents. These agents are usually the directors. From the evidence, it is clear that two persons were actually associated actively with the running of the company as a going concern. They were Edward Ramia, that is the managing director, and Ato Kwashe. Of these two persons, only Edward Ramia was in fact appointed a director in the company. Yeah, so the judge will go on and on and on, and will actually come to make the point that despite the fact that Mr. Ato Kwashe had not been appointed a director, most of the things that he did it as a director. So let me quote a relevant portion of the opinion in that respect. So somewhere in the judgment, let's see, J continue, my quote. The setup in Fruit Supply Ghana Limited is easy to envisage. It was an importing and trading concern. And as I read some of the several letters produced in evidence, I cannot help forming the impression that the company was partially controlled by Ato Kwashe. So pay attention, the company was partially controlled by Ato Kwashe, who exercised authority over its business affairs, as if he were the regular chief executive. But I think the right starting point of Ato Kwashe's exercise of authority on behalf of the company was in respect of signing the applications for the company to be registered as an importer. And this he did with the concurrence of the managing director of this company, Edward Ramia. Besides, Ato Kwashe's own evidence at the trial showed that he was not simply held out as having authority as a director, but that he actually acted as such in relation for his dealings with the defendant in particular. Unquote. Yeah, so his lordship was just trying to make the point that you'll be conversing in relation to section 170 subsection 2, that where a person has not been appointed a director, that person could be held to the same duties and liabilities which duly appointed directors are made to face because of how they conducted themselves in relation to the company, as it were. Good. Yeah, so we will continue unless there are, okay, it's 9 p.m. So being 9 p.m., and then we have to stop here because we go to work tomorrow. But tomorrow we will meet at 7, and then we will continue. Any question? Okay.
Sir.
Yes.
According to section 172,
Okay.
in regard with Commodore versus Food Supply Ghana Limited.
Yes.
Do the de facto or the person who is the busybody director assume such liabilities?
Yes, exactly. So that's why we're making the point that in terms of duties and liabilities, which the law imposes on duly appointed directors, if you hold yourself out as a director, or if you knowingly allow yourself to be held out as a director, or if you are a shadow, if you like, directing in terms of you instructing duly appointed directors, should anything go wrong and then you are identified, you will be held to the same standard in terms of duties and liability, which duly appointed directors are held to. Nevertheless, in terms of rights, privileges, and all that, you are not going to be given, you are not going to be allowed to enjoy the rights and privileges which duly appointed directors actually enjoy. So that is the difference. Okay, so we meet, God willing, tomorrow.